Almost every online course, coaching program, and digital download you can buy carries the same 3 words somewhere in the fine print: all sales final, no refunds. And most buyers read that as a closed door. But here is the question almost nobody asks before they click pay: is that clause actually law? Or is it just marketing dressed up to look like law? We pulled the consumer protection rules apart to find out exactly when a no refund policy holds and when it is worth nothing at all. Start with the part the sellers are right about, because it matters. In the United States, there is no federal law that forces a business to give refunds. A merchant is generally free to write all sales final on a digital product, and for the most common reason people want their money back: plain buyer's remorse. They changed their mind. They didn't have time. They thought it would be easier. That clause usually holds. So the first honest finding is that a no refund policy is real and enforceable in one specific situation, when the product is exactly what was described and you simply regret buying it. But that is a much narrower shield than the words all sales final suggest. Because a no refund clause does one thing only: it sets the seller's voluntary policy. It cannot rewrite the law sitting above it. And there are 3 separate layers of law that sit above it: your card network's rules, your country's consumer protection statutes, and the policy of the platform the seller is selling on. The clause governs none of those 3. Layer 1 is the one sellers least want you to understand: your credit card. When you pay by card, you are not really paying the merchant directly. You are routing money through Visa or Mastercard, and their network rules sit on top of any contract you signed. Both networks have a specific dispute category for goods or services that were not as described or defective. Visa calls it reason code 13.3. Mastercard calls it code 4853. And here is the line that should be printed on every sales page under Visa's own published rules: the merchant's return policy has no bearing on a dispute filed under this condition. Read that again. The no refund clause is explicitly irrelevant to a not as described chargeback. On top of that sits a federal statute, the Fair Credit Billing Act, which gives cardholders the right to dispute charges for goods they paid for but did not receive as promised. You typically have up to 120 days from the transaction to file. So the moment a course is not what its sales page claimed, all sales final stops being the operative document. The card network's rulebook is. Layer 2 is statutory consumer law, and it varies sharply by where the buyer lives. In the United States, even with no federal refund law, many states regulate the clause itself. New York requires a store to post its policy or accept returns within 30 days. California, Florida, Massachusetts, Virginia, and others require a no refund policy to be conspicuously disclosed before purchase, and Virginia treats a hidden one as a consumer protection violation. Across the Atlantic, and the ground shifts entirely. Under the United Kingdom's Consumer Rights Act of 2015, every piece of digital content must be of satisfactory quality, fit for purpose, and as described, and those rights cannot be signed away by any contract term. In the European Union, distance selling rules grant a 14-day cooling off right on most online purchases. The trade-off? For digital content you stream or download, the seller can ask you to waive that cooling off right at checkout, but only if they tell you clearly first. The pattern across every one of these regimes is the same: the law floats above the contract and the buyer's location decides how high it floats. The single concept that ties both layers together because it is the hinge the whole question turns on. Every protection we just walked through, the card chargeback, the United States implied warranty rules, the United Kingdom and European consumer codes, splits the world into 2 completely different cases. Case 1. The product is exactly as described and you simply changed your mind. Here the no refund clause is at its strongest. The seller delivered what they promised, and buyer's remorse is your problem, not theirs. Case 2. The product is not as described. The modules promised on the sales page don't exist. The live coaching never happens, the access is broken, or the explicit guarantee made in the ad turns out to be hollow. Here the no refund clause very nearly collapses. A not as described product triggers chargeback rights, implied warranty obligations, and statutory consumer remedies all at once, and none of them care what the fine print said. So the legal question is almost never is there a no refund clause. It is one thing only. Was the product as described? Layer 3 is the one a seller cannot edit at all. The platform they chose to sell on. When a creator lists a course on a marketplace, they inherit that marketplace's refund rules on top of everything else. And those rules routinely override the seller's own all sales final. Look at the numbers. Udemy mandates a 30-day refund window on eligible course purchases, no matter what an instructor would prefer. Teachable sets a default student refund window of 14 days and lets a school extend it, but builds the protection in by default. And when a purchase is processed through Apple's App Store, the refund is handled by Apple under its own policy, not by the creator at all. The practical takeaway is sharp, where the buyer paid changes their rights as much as what they bought. The exact same course, sold on a marketplace with a built-in window versus sold direct from a private checkout page, comes with materially different refund power baked in before the buyer reads a single word of the seller's policy. Step back, and the whole picture resolves into one clean pattern. A no-refund policy is not a wall. It is a filter. It is designed to stop the easy, low-effort refund, the customer who changed their mind and would rather complain than chase it. And at that job, it genuinely works. Because for pure buyer's remorse, the seller usually is within their rights. But it is close to useless against the buyer with a real grievance and a credit card, because every layer of protection sitting above the clause activates on the same trigger, a product that wasn't what it claimed to be. This is why the sharpest operators in the digital product world quietly run generous refund policies even though the law would let them be stingy. They have done this exact math. They know that a determined buyer with a not as described claim will win through the card network anyway, that the chargeback costs them fees and dispute ratios on top of the refund, and that fighting it burns goodwill they can't afford. The all sales final stamp, in the end, deters the casual and barely slows the serious. So, are all sales final, no refunds policies even legal? The honest, layered answer is yes and almost no at the same time. Yes, they are legal, and yes, they are enforceable. But only inside one narrow box. A product that was exactly as described, bought by someone who simply changed their mind. Step 1 inch outside that box to a product that did not do what its sales page promised, and the clause is overruled 3 ways at once. By your card network, which says your return policy has no bearing here. By consumer statute, which in the United Kingdom and Europe hands you rights no contract can take away. And by the platform, which often mandates a window the seller never agreed to. So before you ever accept all sales final as the end of the conversation, run the one test that actually decides it. Don't ask whether refunds are allowed. Ask whether the product was as described. If it was, the clause is real and you live with it. If it wasn't, the fine print is the least powerful document in the room. And you have more leverage than the seller wants you to believe.